Before we even get into the legal arguments, let's talk about how this case starts, because what you're about to see isn't just a landlord-tenant dispute, it's a masterclass in how courtroom credibility, procedure, and conduct can completely change the trajectory of a case. On one side, you got Golden Pond Estates, a property owner trying to terminate a tenancy. On the other, two tenants, Travis Miller and Randy Bailey, walking into a courtroom already on shaky ground. And when I say shaky, I mean one of them doesn't even show up properly dressed for court. But here's the twist. This case isn't decided on theatrics alone. Underneath the awkward Zoom moments and judicial side-eyes, there's a serious procedural battle unfolding. Jury demands, missed deadlines, conflicting interests, and a judge who's clearly balancing frustration with fairness. What happens when tenants request a jury trial but miss critical filing deadlines? What happens when the alleged misconduct of one tenant puts the other at legal risk? And how much patience does a court really have when respect for the process starts to slip? Stick with us, because this hearing goes from embarrassing to strategic to surprisingly instructive. And by the end, you'll see how sometimes the biggest courtroom turning points don't come from dramatic objections. They come from paperwork, timing, and knowing when to stay quiet.
Ms. Bailey and Mr. Millerans, would you join us, please?
Yes, Your Honor, we're present.
All right, Mr. Millerans there as well?
Yes, Your Honor.
Oh, boy. Mr. Millerans? Would you get up and put on a shirt?
Yeah. Yes, Your Honor. I'm actually trying to find a shirt right now as we speak, Your Honor. Sorry about that.
This is a trial. Boy, I can tell you have great respect for the process. All right.
This moment might seem funny, maybe even trivial, but in a courtroom, appearances matter more than people realize. When the judge calls out Mr. Miller for showing up without a shirt, that's not just about dress code. It's about respect for the judicial process. Judges notice everything, and first impressions set the tone for how seriously arguments are taken moving forward. And notice how the judge immediately frames the misconduct issue, not abstractly, but specifically tied to why the tenancy termination is being requested. That's key. The court is already signaling that Mr. Miller's behavior isn't just embarrassing, it's central to the landlord's claim. Here's the real question for viewers. If you were co-tenant Randy Bailey watching this unfold, would you already be worried? Because from a legal standpoint, shared tenancy can mean shared consequences, even if only one person is accused of misconduct. Do you think courts should separate those responsibilities more clearly? Or is guilt by association unavoidable in housing disputes like this?
The title of this case is Golden Pond Estates versus Travis Millerans and Randy Bailey. They wish to terminate their tenancy primarily because of the misconduct of Travis Millerans, who shows up for court without a shirt. Mr. Steve Cromendike is here on behalf of Golden Pond Estates. We've been tussling with this case since early December. Randy Bailey is present, and Meg Bauer is here from Legal Aid. Theoretically, this matter was set for a trial today on a termination of tenancy. Mr. Millerans and Ms. Bailey wanted a jury trial, and they don't have the wherewithal to conduct a jury trial. They didn't file the information in a timely manner. I didn't set the matter for a jury trial.
Wait, Judge, I'm sorry.
This is where things shift from chaotic to consequential. Jury demands aren't casual requests. They're procedural rights with strict deadlines and fees attached. The judge openly admits uncertainty here, and that's important. Courts don't punish parties for asserting rights correctly, but they will penalize sloppy execution. What we're seeing is a breakdown in communication and timing. Witness lists filed late. Exhibit lists missing. Motions filed before responses were even possible. This is exactly how cases derail before they ever reach a jury. And here's something viewers should understand. Asking for a jury trial doesn't mean you automatically get one if the surrounding requirements aren't met. Procedure is the gatekeeper. So ask yourself, if you were representing yourself, would you even know these deadlines existed? Or does this moment prove why legal counsel isn't a luxury but a necessity, especially when housing and eviction are on the line?
Did they not file in a timely manner?
I can't remember. Maybe I'll take a look. Maybe they did. So you're contending there's a jury demand in here?
Yes, my understanding is that they filed a jury demand within the 5 days of the first hearing and paid the jury demand fee or had it waived.
I'm not sure that's accurate, but all right, let's assume for the sake of argument it is. I set this for today. All their witness and exhibit lists were due by January the 9th, which they filed on January 28th.
I don't believe the plaintiff filed a witness or exhibit list in this matter.
No,
He
they
did
didn't
file
either.
exhibits.
So plaintiff filed a motion for summary disposition that the defendant has not had an opportunity to answer, and they amended the complaint that the defendant has not had an opportunity to answer. So if I understand correctly, Ms. Bauer, you'll be representing only Randy Bailey?
Randy Bailey is the listed client in our system. If the court would prefer that I make my appearance on behalf of both defendants, I can do that. And I am primarily motivated to be involved in this case based on the procedural confusion.
This is a crucial legal fork in the road. The judge explicitly points out that Randy Bailey and Travis Miller have conflicting interests. Translation: what's good for one defendant may be disastrous for the other. From an ethics standpoint, an attorney cannot zealously represent two clients when one's alleged behavior is the very reason the other might lose housing. That's not just bad strategy, it's prohibited. This is also where the court subtly protects Randy Bailey. By forcing separate representation, the judge ensures Bailey isn't legally dragged down by Miller's conduct. Let's pause here and ask the audience, if you were Randy Bailey, would you distance yourself legally from Miller at this point? Or would loyalty override self-preservation? Because in court, emotions don't carry much weight, outcomes do.
Well, one problem is Randy Bailey and Travis Millerans they have conflicting interests. The primary reason they want to evict Ms. Bailey is because of the conduct of Mr. Millerans.
You have articulated my apprehension about appearing on behalf of both defendants.
All right, why don't you go ahead and place your appearance on the record as who you're appearing for.
Thank you, Your Honor. Attorney Meg Bauer, P84816, appearing on behalf of Randy Bailey.
All right.
Your Honor,
Yes,
if I may, Meg and I talked for quite a bit yesterday afternoon, Meg, about a potential conditional dismissal here and what terms of that would look like. I have not been able to follow up with you until now about it. You said you were going to talk to your client, which I suppose is just Randy at that point, at this point. But in any event, has there been any progress on that?
well, I'm glad that Meg is here. These people could use some help. They claim that they had legal knowledge, which they don't, and that you guys can discuss this matter in a rational manner. And nobody wanted to be here today. I appreciate, Mr. Commandant, you were going to have to drive down here from Holland, and everybody would have to be here. So on short notice, I turned this into a Zoom hearing.
This is what judicial triage looks like. The judge recognizes that nobody wants a full trial here. Not the tenants, not the landlord, not the attorneys, and frankly, not the court. By shifting this to a Zoom hearing and encouraging breakout room negotiations, the judge is actively trying to salvage a resolution without burning more time and resources. That's not weakness, that's efficiency. But notice the subtext. Settlement talks only work if parties are realistic. The court is signaling patience, but not infinite tolerance. Jurors should ask themselves, is settlement a second chance or a last warning? Because once this case escalates to a jury trial, control leaves everyone's hands, and outcomes get unpredictable fast.
Ms. Bauer, do you think there'd be any merit to you either discussing it further with Mr. Commandike or with Miss Bailey in a breakout room?
I did speak extensively with the tenants last night, and I thought that Attorney Cromendike also needed to speak with his client. So I have a little bit of an understanding of the range of possible settlements based on my conversations. I am hopeful that something is possible.
I've talked to my client, and I believe he's on board.
All right, how about if I put, Miss Bailey, I'll put you in the waiting room. Don't go away. Meanwhile, Mr. Millerans can get pants and a shirt. And I'll put the two of you in a breakout room and see if you can get the details of the conditional dismissal. And maybe we can have some good result here today.
And Judge, I made it clear to Ms. Bailey that I was going to articulate this to you. But my presence here is primarily in service to the court. Obviously, I have an ethical obligation and legal duty, but
well, I've already said I appreciate your being here, and you all very often help resolve difficult cases, and I do appreciate that. All right, I'm going to put both of you in a breakout room. I'm going to sit here and think deep thoughts for a while, or maybe not so deep thoughts. What's our current status?
Thank you, Your Honor. Attorney Cromendike and I have had extensive conversations, a conversation about the range of settlement terms. And although we're close, we've got a few details to massage out still. So for that reason, we'd like to ask the court to schedule us to keep us on track, that perhaps we have the court schedule a pretrial, perhaps a deadline for witnesses and exhibits in a couple of weeks. And we were discussing that ideally the week of February 16th, but obviously depending on the court schedule, with the hope that we'll have a settlement that we can have executed and entered at that hearing, but understanding that that's a turning point to keep us on track.
And here it is. The paperwork actually existed. The jury demand was filed on time, and the fee was paid. That's a major win for the defense, procedurally speaking. But immediately, the judge pivots to reality. No valid lease, no escrow order, and no rent dispute driving this case. That tells us everything. This isn't about money. It's about behavior and compliance. This is a textbook example of how legal victories can be narrow. Yes, the jury demand stands. But does it meaningfully help the defendants if the underlying tenancy structure is already unstable? What do you think matters more, procedural wins or substantive facts? Because courts weigh both, but juries feel the story.
All right, the clerk did bring in the jury demand. It was in the file. I couldn't find it. It was filed within 5 days of the original hearing on December 5th, and the defendant did pay the $50 jury demand fee. So theoretically, this case would be set for jury trial. There are a couple concerns. I don't think there's currently any valid lease in effect. Do you agree with that, Mr. Commandike?
I do.
We've been tussling with this, as I said, since December. Will be December, January, and February. There is no escrow order in place. Is a plaintiff requesting one?
We're not, and frankly, there hasn't been an issue with payment of rent.
And Ms. Bailey, we've discussed the portal being unlocked.
All right.
Thank you.
All right. Let's look at February 16th.
And
That might be President's Day.
and my thoughts were that we don't bog your schedule down with a day blocked out for a trial at this point. Because if it's not necessary, we keep the date open for the court.
February 16th is a holiday. I normally try to be gone during that holiday, but I'm not.
I think
Let's look at February 13th.
I think, Attorney
13th, I'm going to
Kromendijk,
be out of town.
All right.
Steve, are you okay with the 20th? I know that's typically the landlord tenant days are Mondays and Fridays.
20th would work.
I have an important appointment at Sunset Key, which used to be called Beer Can Island, on February the 20th.
My
So
apologies,
let's
Judge. I
look.
wouldn't want to interfere with that.
I've got to go buggy unless I get out of here again. What's this? That takes us all the way, I apologize, to February 27th, Friday,
27th
February
would work
20th.
for me.
All right. At 11 o'clock. It's going to be problematic because I'm missing so many Mondays and Fridays in February. The days are going to be kind of dense, but I think I may be able to put some things in the afternoon of that day. So we'll block out 1 hour on Friday, February 27th at 11 to 12 for status conference. If the matter is resolved before that time, you certainly can file a conditional order of dismissal at any time. Miss Bailey, Miss Bauer has filed a verbal appearance, and she'll file a written appearance on your behalf, and you've been discussing things at length. Mr. Millerans.
This warning is as direct as judges get. Keep things on a low profile. That's courtroom language for stop hurting your own case. The judge is essentially giving Mr. 2 Miller a roadmap to avoid eviction. No disturbances, no accusations, no drama, because every new incident becomes evidence. From a legal strategy perspective, this is a gift. Judges don't always offer guidance like this, especially when misconduct is alleged. So here's the big audience question. If you were in Miller's position, could you realistically comply, or is the damage already done? Because sometimes the hardest legal advice to follow is also the simplest. Say less, do less, and let your lawyer work.
My advice to you is that you continue to keep things on a low profile. There are a number of things that you are alleged to have done, which is why they want to terminate your tenancy. So
Your
my
Honor.
advice,
Don't interrupt.
but I don't, we haven't got to that issue. They're accusations. So just don't bring up any more accusations. I don't want any more disturbance or discord out there. That'll just make their case easier. All right. Parties did work at resolution, weren't unable to get there.
Yeah, that's a question.
I'm allowed to speak.
Yes.
It's actually for Mr. Kromendijk. Because I was locked out, of the portal, can the $50 late fee that was put there for January's rent be removed? Because Casey did
Well,
ask
we
for
can
the
discuss that later. Right now, you can't pay your rent. In a termination of tenancy case, they can't accept your rent.
But
So
they're
they can't say
asking-
we
We're
don't
not gonna-
accept your rent, then give you a late fee. So you can discuss that with Ms. Bauer.
Yeah.
But certainly keep stockpiling the money if there's an issue regarding rent.
Judge, we're not going to raise a Park Forest waiver argument at this point, but we'd much prefer to have the rent paid.
All right, then you guys can discuss that. Defendant will allow rent to be paid. It's interesting. It makes sense. What happens is people don't pay the rent and they don't set the money aside. They spend it on car insurance or groceries or lottery tickets or whatever. And then when it comes time to pay the rent, the money's gone. So there is certainly logic in continuing to pay the rent. We don't have an escrow order. And that way The rent will not be an issue, so I guess I can accept that. All right, this matter is continued all the way till Friday, February 27th, which is about a month from now, at 11 o'clock. If the matter is resolved, that's fine. If it isn't resolved, we'll set a jury trial date at that time. All right, we will have a finalization of any witness and exhibit list by that time. Mr. Kromendijk, any further?
Nothing.
All right, I'll see you guys in February or sooner if you do work out a resolution.
Ms. Bailey, I will
All
give
right,
you a
Miss
call.
Bailey. My
Yes,
advice
Your
is you
Honor.
stay in contact with your lawyer.
Yes, thank you, Your Honor. Thank you, Meg, and thank you, Mr. Kromendijk.
All right, Mr. Millerant, you as well. Thank you both.
Yep.
Thank you,
Thank
Judge,
you.
for the time. Steve?
In the end, this case wasn't resolved today, but it was reshaped. The court confirmed the jury demand, acknowledged procedural missteps on both sides, and steered the parties toward a possible settlement instead of immediate escalation. The key takeaway? Courtroom outcomes aren't just about who's right. They're about timing, conduct, and credibility. One tenant's behavior nearly jeopardized another's housing. One missed deadline almost erased a constitutional right to a jury, and one judge balanced frustration with fairness to keep the process intact. This case now moves toward a critical status conference, where settlement or jury trial will be decided, and everything hinges on what happens outside the courtroom between now and then. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.